First of all, while the slides are being shown, I would like to thank you, SOGEI, for the invitation, and I would like to thank you all the colleagues, panelists, for their really interesting lectures. The first answer could be why a lawyer is needed among these distinguished panelists. A first answer could be that a lawyer may be always useful, but the real one is that I have been called to address some remarks about legal aspects, which in my opinion it's not discussed enough in their real importance. For example, my colleagues panelists, I don't know if they are aware, have discussed technical slides, but with a legal heart inside. Because, for example, the Italian Space Agency has discussed about integrity, about data accuracy, which may turn into source of legal liability when I add the term lack of accuracy or lack of integrity, and this could be a source of legal liability. Or, for example, Engineer Lisi has presented to us slides with the architecture of the GNSS system. The architecture shows us various technical levels, and in each level there is a level of legal liability. And just to start from the example of of Engineer Lisi, the French train coming from Paris to Moscow. Let's say, to be practical, that while the train is in Germany, in the middle of the journey, a crash occurs. For a failure or for a malfunctioning of the GNSS system providing the signals. Who is liable? First of all, which kind of jurisdiction and which kind of law may be applied to the legal action brought to compensation for damages? The French one because the railway company provides the ticket transportation contract. The Germany one because it's the place where the damage has occurred. Or the Russian one because there is a problem with the interoperability future, because it does not exist, between Galileo and GLONASS. And who can be sued? The signal provider, obviously, yes, in a certain limit, but we will see after. Who can brought the legal action before which court? The end user is, in this case, the railway company, which may the subject suing the signal provider. But the consumer, the real end user suffering for damages, may sue only the company, the railway company, or also the provider of the signal. Is there a public liability in providing the signal? For example, the European Union, as is written in the regulation of December 2013, is the owner of the infrastructure. So as owner and as holder of the IPR, intellectual property right on the whole system, is also the liable subject. We will see that the public subject will deny liability in such case. So this framework, I can say that it's complex not only because we are close to the lunch, but it's complex because legal levels must be stressed and step-by-step analyzed. Okay, grazie. Especially because the legal issues are not only about institutional or jurisdictional aspects. There are problems linked to the certification, security, intellectual property rights, data protection rights. Let me precise that regarding data protection, I will go in depth with this issue in the afternoon roundtable. So I will address. There is only one slide in my relation related to data protection. We are facing a rapidly growing market, a global one, and in the perspective, for example, of Horizon 2020, you must think of a plethora of application, GNSS-based application, and so a plethora of legal issues may arise. I have summarized some of them by recalling the example of Engineer Lisi about the train journey. I will skip several slides because the panelists and the colleagues has already presented. But as a lawyer, I need to build up, to set up a framework to which then successively refer the liability and the legal issues. The framework is threefold. One, definition of a global navigation satellite system. the current systems, GPS, GLONASS, regional one, but I will analyze in a legal perspective, not in a technical one, also because I have seen slides, wonderful slides about it. And third component of this legal framework, the kind of GNSS-based application which we use nowadays, and or in the future we will use. If you think, for example, of the about the Internet of Things, when your washing machine shall call you on the phone to start a washing program, or with your fridge talking with you, recalling you to purchase, or by reading the barcode on the element. Internet of Things. Internet of Things is the current scenario, and GNSS-based applications are relevant in providing Internet of Things application base. Vabbè, così. Okay. I need a commonly agreed definition of GNSS, a space-based positioning and navigation system designed to provide worldwide, the global perspective, independently from weather condition, passive three-dimensional position, velocity, and timing data. This can be an accepted definition of the infrastructure. I'm not an engineer. This infrastructure is very simply based on satellites orbiting the Earth, control and monitoring station on the ground, receivers owned by users. Let's make some remark about these slides. In terms of jurisdiction, we have to consider that services are multi-constellation services. The station on the grounds are located in various countries and in various territories. Who is the competent from a jurisdictional point of view? The second category, the kind of satellite system. We all know there is GPS, there is, I don't know why the Russian flag is the uni moving, but maybe for the war. The GLONASS 1, EGNOS and Galileo, the European, Compass for China, but there are also regional satellite system. It was very interesting, a slide presented by engineer Lisi about the word colored in various zones. That slide was a legal one, because for each color there is a legal regime applicable. So, for example, why the regional satellite system are legally important? Because European Union enter into cooperation agreements to support in some regional area of the world the providing of the future, the soon-to-be Galileo services. So the international cooperation agreement with the regional public authorities or states may address and assess in a way the problem of the liability. We need agreements. I will conclude, let me say who is the killer in my relation. I will conclude by proposing an international agreement on civil liability, because we are moving in a framework where there are no proper rules, and if we try to apply the existing international agreements for damages caused in the GNSS environment, for example, we may recall the transportation airspace, nuclear treaty regulating damages for, they fall out of the scope. There is no GNSS specific laws and regulation nowadays that may assess the problem we are discussing. So we have also the regional system, and international cooperation agreement with the public authorities may be a way to assess also the liability problem. I will skip the slides about Galileo and the services provided by Galileo. It's important to remind that differences between the various satellite systems. Galileo, as it has been already said, is a civil-oriented system, almost exclusively, even if high precision signal may be used for military purpose, while GPS and GLONASS have born and have been developed for military use and scopes. My colleagues before have discussed about technical issues related to interoperability and compatibility, which are legal issues. And in fact, for example, since 2004, there is an international agreement to make GPS and Galileo interoperable. A possible agreement with Russia for GLONASS was under discussion before the latest events. China has signed on August 2014, after 11 years of negotiation, an international agreement with Galileo to support Galileo, to cooperate with Galileo. Is not a... Okay. These slides try to define, from a technical point of view, the interoperability and the compatibility. I will leave you to your attention to go in depth. There are 5 categories of services. Why services are important? Because I must refer to services when I shall discuss about liability. So, which are the services? The services have been presented by the panelists, but can be recalled. Open access navigation. The open services may be considered in arising liability. Usually not, because there is no contract. The basic signal is not even a service provision. But there is a non-contractual liability which may be recalled in case of damages related to the provision of a basic signal. Commercial navigation services and signal augmented signals, which will be provided by Galileo, obviously will be provided within a contractual relationship and also value-added services. So the commercial perspective, where there is a service provider which apply a fee under a contract, when there is a contract, there is also a contractual liability which may be regulated within the relationship. Quickly moving on, the services, because we are talking about satellite, space, but in the practical life, which can be a GNSS-based service which you may use during the day life. The 3 categories of service interlinked, obviously, are navigation, positioning, and timing. We know, as common users of such services, the navigation one. So the services and the signals grounding the services are used to navigate, measure speed, and determine location worldwide in the maritime, marine, space, road, rail, aviation, and so on. The positioning is related to, as the words say, to also mapping, applied in fishing industry, agriculture, and whatever. I shall skip because it has been presented in the previous lectures. Timing is a very important sector in the providing of services. Timing means synchronization, and it is used, such category of service is used in several fields. For example, I don't know if you have the token with the password, OTP, one-time password generated every 30 seconds. This is based on synchronization which may be provided by the atomic clocks inside the satellites. Let's say that in a day, all the financial transaction carried out all over the world must be synchronized by the banks on the financial institution, and synchronization is based on timing services, GNSS based, and so on. Telecommunication, synchronization between radio station on the ground. Even when you tune your radio programs, you are using timing services which may be GNSS based. Encryption, and so on. Okay. Let's come, after this preliminary presentation, to the legal issues I have promised to, in a way, assess. We may start from the concept of liability. We may agree on a commonly agreed at international level meaning, juridical and technical meaning of liability. But then again, the framework can become complex because this concept may be interpreted, may be applied in a different way in different jurisdictions. So liability may be defined as a condition of being responsible for a possible or actual loss, penalty, evil, expense, or burden, and as the state of being bound or obliged in law or contract or justice to do, pay, or make something. This is a very general juridical definition. In the context of Galileo, there is an interesting document drafted more than 10 years ago, conclusions and recommendations, and the legal paragraph are really interesting. But as far as I know, because I do not live with satellite every day or with GNSS every day. As far as I know, is the sole legal documents besides another document in 2010, the UNIDROIT Convention assessing the civil liability for GNSS satellite services. As far as I know, these are the sole documents specifically focusing on civil liability and other legal issues. And let me repeat again that, in my opinion, the legal perspective is not taken enough into consideration by public authorities, by there are the engineering, there are the security, there are indirect consequences of these issues, but facing directly, and I mean, in my opinion, maybe an international agreement could face directly the series of legal issues arising from this presentation for the time being. There is no enough consideration of these issues. Sorry. So in these documents, conclusion and recommendation, there is a definition of liability, the accountability of a person or a legal entity to compensate damage caused to another person or to another legal entity in accordance with specified legal principles and rules. And this obligation may be prescribed in an agreement or in a legal norm. Moving on, what could be the sources of legal liability? Let's leave apart the intervention of fraudulent third parties. Let's concentrate, I cannot be comprehensive, but let's concentrate on threefold: fault or negligence of the provider of the signal, defect of one of the GNSS component parts, and force majeure. There is no doubt that in case of a failure or malfunctioning due to negligence or even fault of the GNSS provider, there is a liability that may be, let's see if enforced or not. Force majeure, even if you, mostly of you are not lawyers, force majeure, it's ordinarily a cause of exoneration from liability, but it's not so certain, because let's say that there is a sunstorm with radiation interfering with the signals. This is a force majeure. But in several jurisdictions, it depends on the predictability of the events. If the events, even going beyond a reasonable, can be predicted, in some jurisdiction you may be held liable, even in case of force majeure. And this may be a source of controversy. Defect of GNSS component parts. There are two kinds of grounds. The first one, someone, but it's a very, it's almost rejected as a position, consider liable the provider of the signal because they consider providing of the signal as a product, so they recall the product liability. This position cannot be accepted. But another, the second ground is the product liability when the manufacturer deliver a defective part of the satellite, of the ground station, of the receiver. Who is liable in case of failure or malfunctioning of the service provision of the signal? Let's say that lacking an international agreed specific legal framework, both the manufacturer and the provider of the signal may be held liable, but the provider of the signal may recall for its exoneration and has a right to recourse against the manufacturer in case of defective components to have the compensation reimbursed by the manufacturer. But it is a possible situation because often the manufacturer may coincide with the service provider. And so in this case, if the product liability may be recalled, some international existing instrument like the Hague Convention on the product liability may be recalled and may be enforced. But then, for example, this convention has only 11 contracted states. One may ask, there is a legal vacuum at all. No, there are rules, there are principles. But the problem in, I have entitled this series of slides, criticalities to enforce legal liabilities. There is not a legal vacuum, but there is the main criticality represented by the lack of a GNSS specific law and principles. So we have to set up a legal paradigm. The legal paradigm is based on contractual liability, non-contractual liability, and product liability. In these slides, you may find a possible definition of this legal paradigm to be applied in order to try to assess the issues of legal liability in providing GNSS signals and services thereof. Contractual liability is the liability regulated by an agreement between two or more parties, and there is the possibility to regulate damages occurred within a non-correct performance of the agreement. And this is the ground where the minors of problems may arise. The non-contractual or tort liability is the law principle related to the damages occurred outside a contractual relationship. And the product liability is the liability which may be imputed to the seller or to the manufacturer of the hardware parts of a GNSS system. If we have on one hand a legal paradigm to be used in order to assess these problems. On the other hand, we have to clarify who the key actors are, who the possible liable subjects are, and there is a legal functional model built to this scope. And which kind of services or signals are provided by these key actors. On one hand, we have the legal paradigm. Contractual, non-contractual, product liability. On the other hand, we have to apply this legal paradigm to the key actors and the various providers, and to the object of their provision. So there is the provision of the basic signal, basic or primary signal provision, and from a legal point of view, this is not considered even a service provision. There are the provision of augmented signals, and there are value-added service provisions. So there is this threefold. Who are the key actors which may be held liable or at least involved in a legal action? There are basic signal service providers, augmentation signal services provider, value-added services provider, end user. The end user is, for example, the aircraft company or the railway company in the example we made some minutes ago, and the final users holding a receiver. Let's move on. Generally, the basic signal do not raise any contractual liability because the provision of the open services and the provision of the basic signal are made for free. There is no fee, there is no contract. Everyone holding a receiver may use for free, and the service provider cannot monitor the use, cannot have any kind of control. But it is discussed because even if the public authorities deny a contractual liability for the providing of basic signals or for open services, someone has pointed out that, for example, it is true that there is no contract, but there is, in the legal paradigm, the possibility to ground an action based on tort or non-contractual liability. Why? Because even when providing basic signals, the authorities, the governments, the holders of the infrastructures made declaration or release authorization on even the provision of basic signal on which the end user may rely. And another more technical legal remark is that the compensation for damages at an international level is based on the concept of harm occurred, and not on the concept of fault. Because the governments may say, we have no fault because we provide open services and basic signal for free. There is no fault to may recall or which may ground legal action. But the liability is based on the harm, is based on the damage occurred. And so, in the other, moving on, in the other voices of the legal paradigm, contractual liability, in the provision of augmentation services and in the provision of value-added services, there is less minor problem because here there are contracts, because the augmentation signal is provided within a contractual relationship, there is a fee to be paid, and also the value-added services based on the augmented signal are regulated by a contract. So within a contractual relationship, we may assess also the liability issues. Okay. In these slides, I want to recall the fact that how to prevent liability, how to handle these issues by technically strengthening the continuity of the signals, accuracy, efficiency, availability, and reliability. It's just a slide recalling that if we act before by setting up modern infrastructure, maybe the possibility of legal liability arising can be handled in a way. Another problem is that if we may agree on the concept of liability, but there are criticalities in enforcing and all the issues I have tried to summarize in these minutes, there is another problem. Which damage can be compensated or reimbursed? Because if we are within a contractual relationship, there is no problem. There is the direct damage to be compensated. But what about indirect damages? What about jurisdiction where some particular kind of damages exist, like the punitive damages in the United States, which is a category of damages which is prohibited in Europe from compensating? So if we face with a global market providing a global set of services, and if we have the difficulties in imputing in a particular jurisdiction, in grounding in a particular jurisdiction a legal action, then we shall have difficulties in handling with the legal concept, because in that jurisdiction some damages are applied in a certain way and may be recognized or not. There is another legal issues related to the third-party liabilities, because when we discuss about contractual liability, the counterparts are, for example, the holder of the infrastructure, the service provider, which may be a public authorities, and, for example, the railway company, which is the end user using the signal. What about the liability towards the individuals, the single consumers? Let's think again to the example of passengers of a train wounded in a crash. Who is liable? May these individuals sue who? This is another problem. Are the public authorities liable? The public authorities shall deny liability. So a single final consumer may sue, besides the railway company, also the provider of the signal when the provider is a public authority. It's another issue. Let's say that limiting to Galileo, there is an important article of the European Union Treaty, the Article 288, which is the general law principle regulating the liability of the European Union and its officers. The contractual liability of the, let's read this article and I will comment. The contractual liability of the community shall be governed by the law applicable to the contract in question. And so, you know, in an agreement, you may choose the applicable law. But in the case of non-contractual liability, the community shall, in accordance with general principles common to the laws of the member states, make good any damages caused by its institution or by its servants in the performance of their duties. The non-contractual liability, according to this treaty article, recalls other criticalities, because what does it mean in accordance with the general principles common to the laws of all the 28 member states? I don't know. There is this regulation dated December 2013, which is highly interesting. It's the regulation about implementation and exploitation of the European satellite navigation systems. It's a recent one. But there are some parts, even if the legal issues we are discussing are not faced at all, but there are some parts really interesting. For example, the premises number 22 say, it is important to note that the investment and the operating costs of the systems are estimated for the period 2014-2020, do not take into account of unforeseen financial obligation which the Union may be obliged to assume. In particular, there are not taken into account the costs relating to liability arising from the performance of the services or from the fact that the Union is the owner of the infrastructure, especially with regard to any malfunctioning of the system. Those obligations are the subject of a specific analysis of the Commission. When? Article 6 of this regulation specifically provides the ownership and say, okay, the European Union is the owner of the Galileo, EGNOS, and other satellite infrastructure. So as a lawyer, I may say, you are the owner, you are the liable. No, it's not so clear because, for example, in managing the related intellectual property rights related to the satellite system, the European Union may enter into license agreements. And so again, there is a step in the various level contractual relationship where the matter of liability may be regulated. How? Is the licensee holding liable? Maybe this could be a way. But the general principle stated in Article 6, the European Union is the owner of the infrastructure, may lead, in my opinion, to a certain liability, may entitle the liability of this public authority. Other legal issues related to data protection. We say, we shall go in depth in the afternoon, but data protection is a major issue in providing GNSS services. And we know that, especially now in Europe, a new regulation on data protection is under discussion, a general new framework, because the data protection directive is dated 1995, and this regulation is actually under discussion, approved by the last European Parliament. But the regulation of December 2013 related to the implementation of satellite systems say, regarding data protection issues, you have to simply apply the data protection directive and the regulation related to data processing by institutional European authorities. Regarding liability under the data protection legal framework, there are possible non-contractual liability. There is a particular category of damages, the damages following data processing. Who is the liable subject? Is the data processor. Who is the data processor? Maybe the provider of the signal, but maybe also the owner. This is why I have discussed these two slides about EPR and data protection together, because according to the data protection law, for example, to the European laws, the data processor is maybe not only the signal provider, even a licensee of the European Union, but maybe also, and usually is also, the owner of the infrastructure processing the data. So, according to data processing, we may recall a possible liability of the European Union like owner of the infrastructure. And the conclusion is, in my perspective, that of drafting and agreeing on an international agreement about civil liability in providing GNSS services. Why? Because we have already pointed out that the existing international regimes, legal regimes, meaning international treaties regulating liability in specific sectors like air, space, and nuclear, are not fully useful in assessing the legal liability. The lack of a specific GNSS legal framework regulating also the liability impact, for example, on the insurability of the services. service. There is a problem of insurability which may be assessed by an international agreement, clarify the various liability. And this is the slide related to why an international instrument may be useful, because it may regulate fraudulent intervention of third person, force majeure, qualification of GNSS signal as a service, liability for product for failure or malfunctioning, and a unique, a sole regime may handle, for example, the problem of the open services. Our product, our services, contract liability are not applicable, but tort and no contractual liability may be recalled, and so on. The final user may rely on a uniform set of rules and legal principles. Whichever the signal provider is, whichever is the field, whichever is the service. And this is the slides. And so, finally, an international treaty, an international agreement on civil liability in providing GNSS service may also be based on the cooperation not only of states or supranational authorities like the European Union, but also other international organizations, just because we are facing with the global market and with the global services, may be involved in setting up this global set of rules and law principles which may regulate and assess the legal issues I have tried to summarize and to discuss in my presentation. And so thank you for the attention, and I'm available for any kind of question.
Thank you very much, Alessandro del Ninno. I think Marco Lisi wants to... You're the only one making a question now, because after we have lunchtime.
And have mercy of the poor lawyer.
No, but it's more than a question, it's a clarification. I should congratulate with you because I found it very interesting with a lot of stimuli. And I'm not going here to answer some of your open standing questions. Nobody can at the moment. But
Absolutely.
just let me say, let me say two words about sti microfoni. Okay. Yeah, please. Just a clarification about the completely different perspective, again, without giving any solution, there is no answer at the moment, between GPS and Galileo. GPS is strange. It started as a military system.
Yeah.
Now there is a huge involvement of the government on civilian applications, so much so that there is a board, a government board that puts together several departments, not only the Department of Defense, taking care of the application of Galileo at large, of GPS at large. So there is an involvement. So also, on top of that, there is also a service declaration document that if you go to the gps.gov site, you can read what is the commitment at government level vis-à-vis the users and service providers, again at large. But notwithstanding this type of involvement that you would see as implicating also a commitment on the liability side, they have solved the problem at government level of liability with a disclaimer.
Yeah, reject.
This is important because someone could not have realized that whenever you buy something based on GPS, may be written in the famous small characters, there is a disclaimer: the US government is not liable for any type of application that deriving from the use of GPS and of this device.
Is one of my skipped slides.
Okay, no, but this is important. Now, in Europe, we are starting.
Even if a tort liability is under discussion, the government of the United States...
I'm not aware of any winner.
But you have to ground the legal action in the United States. This is the pre-requirement.
So, which is a limitation.
Yeah.
Now, in Europe, we are starting, but and we are probably going to the same path. There is a fundamental difference, though, that while the US government could say this system was paid for something else as objective, it was funded for military application. So the fact that civil people use it is a byproduct. So take advantage of it, but do not ask me for any commitment. In the case of Galileo, it's just the opposite. In the case of Galileo, it is stated down that we are doing it for the user, for the European citizens first, and in general for whoever can use it in the world. So this is the problem with, it is not solved. The problem is that it's like, the comparison is like a bench in a garden, in a public garden. You sit to the bench breaks down and you break your leg, okay? Is the administration, the local administration suitable? Yes, the answer is because that was for the sake and for the benefit of the citizens. So if instead of a benefit was causing a damage, it's obvious that you should be liable. The same should apply with the same principle to Galileo. If Galileo was done as a service for the European citizens and something goes wrong, and instead of being beneficial, it is harming the European citizen, then the European citizen, someone says, should have the right, and so there is no possibility of a disclaimer in the case. So it is open, there is no answer to that, but just to explain the big difference. The big difference here, if you trace back from the origin Galileo, in terms of money, in terms of political objectives, everything is stating that is done for the community, for the European community, the community of European citizens. So there is no way to deny that the original purpose was for the benefit of the community and not for other purposes. This makes the picture very complex and completely open so far.
You know that also on other grounds, the relation between European infrastructure and US infrastructure is critical. For example, in data protection, we as Europe face with a very regulated framework, while in the United States there is no federal laws on privacy, and so when data are transferred from Europe to the United States, we have similar difficulties like the ones you were pointing out. For sure, the United States provide GPS for military scope, and so in the military sector there are high precision signals. If you want to use GPS to for civil purposes, you do at your own risk, and the signal is not high precision one, while Galileo, in providing commercial services on a civilian ground, shall provide especially. Yes, there is contract. So I know, but I have no answer. I have preliminarily confessed the killer of my lectures, and that I only could propose a possible solution. In my opinion, in a global world, an international instruments could assess also these kinds on one hand. On the other hand, let's say if the United States government's authorities, let's sit on the table, it's, or the Russian one, it's really, I don't hide the difficulties in creating such environment.